Good morning, this is your Kelso Report for Friday, February 3rd, and I'm your host, Clark Kelso. The internet has all sorts of tools designed to help users connect up with other people for a wide variety of purposes. One such website, roommate.com, helps people find roommates. The site permits users to select roommates based on, among other characteristics, sex, sexual orientation, and familial status. Well, you guessed it, the website was sued for an alleged violation of the Fair Housing Act's anti-discrimination provisions. For the Ninth Circuit, in Fair Housing Council versus Roommate.com, the case came down to the simple issue of whether the Fair Housing Act extends to choices about shared living situations. In other words, does the FHA apply to roommates? The answer was pretty straightforward, actually. The Act prohibits discrimination on the basis of, quote, race, color, religion, sex, familial status, or national origin, close quote, in the, quote, sale or rental of a dwelling, close quote. The court interpreted the word dwelling to mean the overall living unit, such as the house or the apartment, and the court refused to subdivide the living unit further into separate areas for each roommate. Well, given this interpretation, the FHA simply has nothing to say about someone's decision to discriminate in the selection of a roommate. In support of its holding, the court noted that Congress was intending here to address the problem of landlords discriminating in the sale and rental of housing. And nothing in the legislation suggested Congress intended to interfere with personal relationships inside the home. Relationships that themselves are deserving of independent constitutional protection. Our next case from the Ninth Circuit deals with simply a courts question. Now, nothing has been ordinary in the case challenging the constitutionality of California's Proposition 8. Now, as you may recall, the trial judge in the case had decided shortly before trial that he wanted the trial to be broadcast. And he changed the court rules very quickly to try to make that happen. Well, that effort was quickly overturned with the Supreme Court of the United States in Hollingsworth versus Perry. Even though the trial wasn't broadcast, the trial judge went ahead and videotaped the trial, ostensibly for his own personal use in chambers. This videotaping was done only after the judge promised the parties that the videotape would never be publicly released. And the judge ultimately entered the tapes in the record and sealed them. Well, the trial judge has since resigned from the bench, and what do you know, a new trial judge decided to unseal the videotapes. The Ninth Circuit, quite properly, I think, issued an order yesterday in Perry versus Brown, holding that the new trial judge abused his discretion in ordering the tapes to be unsealed. Putting it bluntly, the panel explained that, quote, the integrity of our judicial system depends in no small part on the ability of litigants and members of the public to rely on a judge's word, close quote. My own guess is that if the Ninth Circuit had not acted, the Supreme Court probably would have acted, since this whole affair has the smell of an attempt to get around the Supreme Court's first order. Next, we have two death penalty cases from the California Supreme Court. The court, in the first case yesterday, People versus Elliott, unanimously affirmed a death penalty with an 82-page opinion rejecting all of the defendant's claimed errors. In the second case, People versus Brents, the court affirmed the conviction for first-degree murder by a 6-1 vote, but the court here did reverse the penalty because of instructional error. The trial judge in this case had instructed the jury on a kidnapping special circumstance that it did not need to find any independent felonious purpose for the kidnapping. The Supreme Court concluded that was erroneous, since under its precedents, the prosecution had to prove that the kidnapping was not merely incidental to the murder. Since the jury was incorrectly instructed on the special circumstance, the court had to strike it, and that required that it reverse the death penalty. Our next case involves community property. The 6th District held in Walker versus Walker that a CalSTRS disability allowance paid to the husband, payments which commenced after the couple's separation, that is considered separate property, and those payments have no impact on the wife's community property interest in the husband's CalSTRS retirement benefits. This difference in treatment is because a disability payment does not serve primarily as a form of deferred compensation for past services, such as a retirement benefit. The retirement benefit is part of community property. But the disability allowance is instead simply compensation for the loss of pay caused by premature retirement. And so long as that disability allowance starts after the couple has separated, those payments are considered separate property. Next, we have a civil procedure holding involving validation proceedings. Now, as you know, certain public agencies may have their actions tested and approved through the mechanism of a validation action under CCP Section 870. A central theme in validating procedures is the speedy, dispositive, and final determination of the validity of a public agency's actions. Accordingly, Section 870 of the CCP provides that, quote, the judgment in a proceeding brought under the general validation procedure is binding and conclusive against the agency and against all other persons, close quote. In Icecamp versus Pajaro Valley Water Management Agency, the 6th District held that a judgment entered pursuant to a stipulated agreement in a validation procedure challenging 3 ordinances that increased groundwater augmentation charges was res judicata and thereby prevented a subsequent taxpayer who hadn't been part of the lawsuit at all previously from bringing a challenge to those same ordinances. It's a very broad application of res judicata under the validation procedures. Next, we have a sanctions case. The trial court in Wall versus Perkins essentially did everything it could to secure the wife's participation in appropriate hearings regarding custody and visitation. But over a period of almost a year, the wife regularly failed to appear at scheduled hearings without explanation or justification and flouted multiple court orders and had all sorts of frivolous filings. And at the end of this period, the trial court sanctioned the wife $552,000, a huge sanction. And guess what? The 6th District not only affirmed, but for good measure added $15,000 in additional sanctions for the wife's frivolous appeal. There were 2 lawyers who had provided some support on appeal, and the 6th District ordered each of them to pay $5,000 in sanctions. That's not a good person, a good client for lawyers to be near, apparently. That's it for today's Kelso Report. Have a good weekend and a great day in the law.